Hello, and welcome to Crime in Court. My name is Heather, and this is the continued story of Zachariah Anderson and the Wisconsin versus Zachariah Anderson. As you can see on the thumbnail, this is episode 5, The Unseen Evidence, and that is what we're going to go over today. So, I'm getting my information, everything today from the free ZachariahAnderson.org webpage. I believe his family and some close friends have put this together. It's an amazing website. It has so much information on here to help you really understand this case if you have any questions about it. So we're going to read off the unseen evidence today and discuss. So this is a map where, remember, Rosalio lives down here in Kenosha, and Zach's apartment is all the way up here in Mequon, Zach's house. I don't know if I said apartment. I meant to say house. He has a house. Rosalio has an apartment. All right. So, the state alleges that Zach ended Rosalio at Rosalio's apartment in Kenosha and then transported his body using his own van that he uses for work and drove him all the way back to Mequon that evening. Rosalio's phone had an orientation change at 10:10, indicating that it was handled by either 1, the person who ended Rosalio, or 2, Rosalio himself. So it's very possible that Rosalio touched that phone, but we don't know. And then we don't know who touched it last, and I don't think it was ever really investigated. So that's a good question about that. All right, so Zach placed a phone call from his own home at 11:19 p.m., which is verified by the ping off of a nearby tower from his assault tower near his house. So it is verified and confirmed that he made a call at 11:19 p.m. According to those two events, there is at max 1 hour and 9 minutes in between for drive time. Okay, and this takes a while to drive, just so you know. There are anywhere between 33 and 44 traffic cameras on the major highways traveling from Rosalio's apartment to Zach's house, as designated in the above map by the blue pins. So all of these blue pins indicate there is a some kind of recording device, some kind of camera overlooking portions of the highways that he would have had to take to get back home. The fastest highway route between Zach's and Rosalio's is 1 hour and 1 minute. That's per Google Maps. However, Google Maps now shows it's 56 minutes, but at the time there wasn't an exit by Zach's house, so they recently put in a new exit at Zach's house. It didn't exist in 2020, so there's no way he could have made it home in 56 minutes at that time. The fastest non-highway route, so if he took back roads to try to avoid cameras, would be 1 hour and 24 minutes. Therefore, he couldn't have made that phone call at 11:19. So, and even if he did do a highway, which we have no proof that his phone or that his car was on any highway road at that time, because we have all these cameras and there's no footage indicating that Zach was driving down those highways. So what does the evidence show that they do have? although Zach could have made it home in the 1 hour and 9-minute time frame using highways, his vehicle would have had to have been spotted on at least 33 traffic cameras, so we know that this is not the case. If it were, two things have to be assumed for this to be true. One, that it wasn't Rosalio himself handling his phone at 10:10, which means it would be the person who ended Rosalio, and then that person wouldn't be home in time to make that call if it was Zach. So, anyways, there is no, and two, that his phone was put in the freezer at 10:10 p.m. and then an immediate mad dash to the car occurred. So this is a scenario. If Zach did this, if it was that he was guilty, he would have had to have put the phone in the freezer himself, or Rosalio did at 10:10, meaning that he would have been still alive too. So the state's theory just doesn't make any sense. There is no evidence that shows that Rosalio was definitely unalive before 10:10 p.m., so it is absolutely possible that he could have moved the phone at that time and then been ended afterward, which would make the timeline impossible. The state's timeline doesn't make sense. The scene, although also does not support the theory because, one, the apartment lights were turned off. Two, a bag of tools was left directly in front of the patio sliding door, which is the likely exit point. And three, the patio curtains were closed and the screen door was closed. So whomever was there took the time to close down the apartment in a way that would ensure the crime scene would not be discovered right away. Very true. And I often wonder that too, like did the person, the unender, or the life ender, did he turn the diffuser on to mask any odors or anything that would be in the apartment from the BLOOD that was in there? So I kind of, I questioned that myself, but it still would have had to be within that 18-hour time frame if that were the case, because that particular diffuser only ran for, I think, 18 hours or something like that. So not over 24 hours. Would be unusual for that to happen. All right, so the scene also does not support the theory because, one, the apartment. Oh, I read that. Okay, so whoever did that, they turned the apartment down and tried to mask any signs of a crime occurring there. So because Zach was not seen on any cameras reviewed by Kenosha PD, it is reasonable to assume that he would have had to have taken non-highway routes to avoid cameras if it was him. This makes the state's timeline impossible unless he was going well above the speed limit through the major city of Milwaukee, which I doubt you'd be driving super fast after you just committed a crime and then had a body in your van. So that wouldn't make any sense. There's no way he would be risking speeding or running red lights, like I just said, and getting pulled over because cops could easily see a body in the back of his minivan. And just because he would have avoided the highway traffic cameras doesn't mean that he would have avoided all cameras. And I was thinking that too, because there's cameras everywhere. There's cameras, on private businesses and like covering their lots, and it gets part of the street. You can identify cars that way. So it could be privately owned cameras. Anyways, what did I say? Oh, Kenosha PD also checked camera footage at places like gas stations and schools and still did not see any signs of Zach's van. So we know they have no footage of Zach's van whatsoever. What does this mean? The extremely narrow to impossible timeline coupled with zero footage of Zach's van traveling the long distance between these locations makes it impossible for Zach to be the unaliver of Rosalio Gutierrez. There is zero evidence that exists that shows that Zach ever left his home, and the timeline doesn't work. So, like I said, there's no way with the drive time. He still would have to carry the body or somehow get the body into his van by himself. That would take time, and I don't know how you would do that in a busy apartment complex at a time of night when people would be out and about, potentially. Let's see. Oh, we read through all that. Okay, so why Sadie and OA's testimony doesn't add up. And you know what? I'm going to do an episode on key witness testimony and looking at, credibility of certain people that were on the stand. And then I think, we'll do maybe a couple episodes picking apart like a little bit of people's testimony from Zach's trial. All right, so why Sadie and OA's testimony doesn't add up. So here's Sadie's home right here. Her living room windows face out this way. Okay. Zach's typical route home, he would be going that way, so you would potentially see him from their living room window, maybe, depending on your view. That this little unit or whatever this is might be blocking their view of anything anyways. All right, so where OA testified that this circle right here is where OA, their daughter, testified that Zach pulled into while leaving the path while leaving in path to the front door. So this is the path to the front door, and Sadie and Zach's daughter is saying that this is where Zach pulled into. Probably to look at Rosalio's, at that incident when OA had testified to Zach going into Rosalio's car. And that was, this is what that's in reference to. There's a bunch of large bushes here. And then there is a bar right here, and this is the parking lot to the bar. Or maybe that's the bar. Sorry. This is the bar. I don't know. That's some shed. OA testified that Zach parked and backed into this parking lot. But here we can see Sadie's front door. And this is a different unit here. You can see the large bushes and the parking lot to the bar. The bar's over on this side. You can't see it. That was that little shed in the back. Oh, it's a garage. And then this is where OA said that Zach pulled in backwards. That is not Sadie's unit. Sadie's unit is blocked. This is why this doesn't make sense, because you can't even see from Sadie's window if Zach were here, because Sadie said that she saw him pulling out. She didn't see, she just saw a black car, but she knew he had a black car. So that's why, I mean, she knows that he drives a black car and a black minivan, and she said she saw a black car backing out and pulling away, leaving her house, which, like any black car, and there's a lot of black cars out there. That doesn't necessarily mean that it's Zach pulling into your driveway. So she could have just said, oh yeah, I saw a black car and it's Zach's. She could have just been putting that belief on it because she was acting so crazy, maybe paranoid. Maybe she was on some kind of pills or illegal substance that she might have been taking that were making her paranoid and making her think that Zach was following her and making her think that she had reasons to be paranoid by what he was doing. I don't know. I do know that their information just doesn't line up, though. So again, here's where Zach supposedly pulled in and rang the doorbell and then drove off. And that was according to OA's testimony, which makes no sense. Why would he ding-dong ditch her? I don't know. People do weird things, so I don't know. If he was an obsessive, crazy, jealous ex, you know, I could see someone doing that to try to interrupt them or whatever, but it's childish and stupid, and it doesn't seem like he was being very... I feel like he was being the more mature one in the relationship and trying to take care of the kids at this time, where Sadie was being irresponsible and heading to the bar without, you know, someone at home with the kids and things like that. So there's been some issues along the way where Zach was worried for his children's well-being, and he was trying to get custody of them, which ultimately led to everything that came to what happened, I think. So anyways, what to consider. OA testified that Zach took her to Sadie's house in the very dark hours on the night of April 24th to, quote, spy on Sadie and Rosalio. She stated that Zach had parked in the bar parking lot and backed into a parking space. She states that she stayed in the front seat of the car and watched him go up to the living room window. She saw him put a recording device in the air conditioning unit attached to the living room. That's what, according to OA. Then she testified that while leaving, Zach pulls the car into the second driveway, gets out of the car again to go take a picture of Rosalio's license plate and steal some papers out of the car. She then says he rings the doorbell before running back to the car to drive away. Sadie testifies that after the doorbell rings, she looks out the window and sees a black car speeding away, assuming that it was Zach's. That's all, you know, circumstantial evidence too. I mean, I don't know. And I think it's difficult to trust OA's testimony because if you look at any of the, if you've watched the testimony or the interview with Sadie, which OA is in the video for the later portion of it, she comes into the room after she was interrogated about it. You can almost feel like Sadie may be feeding her stuff at home. I don't know. It almost seems like Sadie loves drama and she wants to and she brings that drama to her kids, is what my impression was. And sometimes kids, you know, they see their parents' behavior and they do that to try to get their parents' behavior. So if or to try to get their parents' approval, they repeat that behavior. So if, you know, mom is bashing Zach, OA might be like, oh yeah, I saw dad do this and that and whatever, because she wants to get in good graces with Sadie. So it's touch and go for me of like what to believe for a kid. It's like, yeah, but why would a kid lie? Yeah, but they do sometimes. And especially if you listen to Zach's interview, you can hear that she just makes stuff up. She had been stealing her aunt's cell phone and like doing some things and lying about them. So it's hard to believe everything that OA testified to. Plus things don't line up anyway. So here's what she states. All right, so Sadie testified that she saw a black car speeding away, but she knows what Zach's cars look like, and he was driving, according to OA, I thought, the minivan. So it wouldn't be a car, it would be a van. So, and she would know, like, oh yeah, I saw a van that looks just like my ex's. She didn't describe it like that. She just said, I saw a black car speeding away, which makes me think it didn't happen. All right, so what the evidence shows, if you look at the maps above, there are a few major inconsistencies with their testimony. The living room window is oriented on the exact opposite side of the house as the bar parking lot, with lots of large bushes in between. So it is impossible for OA to have seen Zach go up to the window from the car, let alone be able to see in detail what he would have been doing there. So OA said Zach pulled in, like where this van is, like, well, I don't know there, but like Zach pulled in here and then went to peek in the window. So how would OA see Zach peeking in the window from the parking lot of the bar? Doesn't make any sense. Whoops. Where was I? All right. The front door is tucked back completely out of the sight line, and I showed you that, of the second driveway because of the other unit attached looking just out or jutting out so far. So it is impossible for OA to have seen Zach go ring the doorbell from the car. So let's look at that vantage point again. So this is where he would have pulled in his car, according to OA. And here is Sadie's front door, and there is a unit right here with the big X on it, which is obviously not Sadie's unit. So Sadie's front door is back and behind this unit here. It's obstructing the view. So where was that aerial view? Here. This is somebody else's unit within this complex or whatever. So, oh no, it's here. This juts out, so her living room wouldn't. Yeah, this is the unit here. That's probably another unit as well, but this is the unit here that juts out. So Sadie's window here, how can you see through this building here? So there's no way that he could have pulled up anywhere and then just gotten out of the car while she sat and watched and Zach did things in front of Sadie's window. It doesn't align with the testimony at all. So there's that. All right, so what else? All right. Also, because of the lack of sightline from the door to the second driveway, plus the fact that Zach's typical route back to his home leads away from the front door, not crossing past it again, it is impossible for Sadie to have seen Zach's vehicle from the window. So, there you have it. All right, so what does this mean? There is no way to reconcile these impossibilities with what with both Sadie and OA testified to, other than that they were either complete fabrications of fact or partial truths that were, for whatever reason, embellished. OA was 11 to 12 years old at the time all of this occurred, so there's a high likelihood, based on age and the way that the brain functions during the stage of development, that she is misremembering. But how could she misremember completely impossible details that line up exactly with what Sadie remembers, like ringing the doorbell? If this event does show an indication of false memories, what other memories does she have that are false and only come from many years of discussions around these events? Again, this opens the door to the idea that much of what OA says she remembers from the time period is false. These memories that she supposedly has could be very well implanted in her mind by Sadie. Having been exposed to Sadie's stories and whatnot, talking about this. So there is special evidence of this at trial. So OA is able to state what exactly, specifically, how many plants of ganja that Zach was alleged to have. I don't know if I could say that word on YouTube, but I'll use ganja. All right, so was alleged to have, but she was unable to identify a picture of what ganja looks like. She claims in testimony that she went down to Zach's basement because one of her brothers dropped a Lego down the stairs, and she went with him because the basement was creepy. But in her original police statement, she said her brother was playing down there because he liked it. So, just weird inconsistencies. In her original police statement given on May 19th, 2020, she stated that she never saw any GUN reference stipulated testimony by Lauren Anschutz, the detective, and nearly 3 years later on the stand, she claims that she was threatened with a gun. She blurted that out with no question being asked, that she said that she was threatened with a gun. I believe that they struck that testimony, but you can't unhear that if you're the jury. So this would indicate, because she never saw a weapon, but she's saying that she was threatened with one. So this would indicate that the false, excuse me, that the memory is false, and that it was implanted through suggestion during the numerous conversations she had with Sadie, police, and the prosecution. If Sadie is a storyteller, one of those types of people that likes drama and spins stories, that could easily rub off on the daughter. Even unintentionally, it might rub off on the daughter because she sees it, so she repeats it. Remember, OA has no contact with Zach after the arrest, so she only hears about and or talks through these events with people trying to find evidence of Zach's guilt, which leaves a very high likelihood for suggestion. And she is very impressionable. She's still a minor, I believe. And if you're having one side always tell you your dad's guilty and this is why, and bashing him, then yeah, she's gonna probably start to believe that. Alright, so through early adolescence, children's ability to remember exact details is poor relative to adults, which makes them especially prone to false memories arising from suggestion. And that is coming from Charles Brainerd, PhD, a professor of philosophy at Cornell University. And this page also provides a scientific article that you can read about this very topic, where you can suggest memories. You can provide false memories to your children by certain things that you say. Alright, so, however, Sadie is an adult with a stronger memory capacity, so misremembering, although not impossible because we all have memory issues, but it is far less likely for her to misremember all of these events in a certain way. So she claimed from her very first statement to police that she had seen what she assumed was Zach's vehicle drive away, so it is not a distortion in memory that happened over time. Sadie has a strong motive to lie and or embellish truths because it was her goal to get Zach arrested on stalking charges. Remember? She wanted him, I think she wanted him behind bars because of custody, because he was going for custody. I mean, it makes sense. She didn't want him to have full custody of the kids. Right, so she claimed from her very first statements to police that she had seen what she assumed was his car. Sadie has a strong motive to lie and embellish truths. She felt like her claim wasn't strong enough to get the job done in the past, as she indicates by stating that police previously didn't do anything and denied her a restraining order. So she was trying to get a restraining order on him for a while, I guess. Therefore, it is highly possible she could have chosen to embellish or make up details that would make her claims more valid, to make it seem like he was really crossing that line from being the ex-boyfriend to stalker, when in reality we saw the text and she was still calling him Z-Bear and asking him, why didn't you sleep over last night? So it's just strange. It's just very strange that she would... I feel like she was two-facing him at that time. Like, she was lying about not seeing someone else when we know she was now, and I think she was just stringing him along. Anyways, I had contacted Germantown Police Department with my concerns about the stalking behaviors. They told me that they were not able to do much unless I caught him in the act, she says. Or she told that to News Graphic, whoever they are. She told that to the media. So, in her own words, her previous concerns of stalking were purely anecdotal, and she had no hard proof to concern officials enough to produce an arrest or restraining order. So that's important, indicating that there was a lack of her validity, her credibility. Anyways, therefore, they had to be sure that she found ways to, quote, catch him in the act this time, stating he rang the doorbell and she saw his car drive away, stating that him accidentally dropping his phone in her car was an intentional plant for tracking purposes. So for all those reasons, she built it up. Maybe she stole his phone and put it in there for the purpose of saying, like, look, he's tracking me. I wonder. I really, truly wonder. There are people out there like this that do things like this, and I'm almost getting this. I'll just say, yeah. I'm not insinuating or, coming out and alleging that anyone else did these crimes. I mean, someone else did these crimes. I'm not pinning it on anyone in particular, but I am saying things are suspicious in this whole case. So regardless of the reason of these factual errors, all testimony of both Sadie and OA should be scrutinized with a fine-tooth comb. We're going to look at them. So if you watch with careful consideration, you'll notice that none of their testimony has a single thing to do with the disappearance of Rosalio Gutierrez, and much of it is either false or purely based on assumptions, hearsay, and irrelevant information. So we'll look at that and look with that perspective, watching their testimony in some upcoming episodes. So why the spec from Zach's minivan is completely misleading. Completely. So this is a luminol test. This is not from Zach's house or anything, but as you can see, it's a bathtub. This is how luminol would light up if you had biological material there. That's what it looks like in the blue light. This was Zach's van. Where's the blue light? I don't even see it. Example of how luminol reacts to BLOOD. The bottom is the inside of Zach's van during luminol testing. Where do you see BLOOD? Where? I'm looking. I'm really, really looking. This is the color. It should light up neon blue. Nothing. Nothing. What to consider? Luminol is a solution capable of detecting BLOOD that has been diluted up to 10,000 times. So it's a very it's very capable. It's very effective at finding biological material, even if it has been cleaned up and diluted at some point in time. So once luminol comes into contact with the biological materials, it reacts by causing it to glow a pale blue color, which we see in this top portion. It's blue, but neon, very bright. You can't miss it. All right, so luminol also causes a similar reaction with oxidizing chemicals like bleach. Although there were no pictures of it, the crime lab also used phenolphthalein in the van, which is a presumptive test that will turn pink it will turn pink to the presence of certain molecules that are in the blood. So, yeah, we don't have that either. We don't see pink either. What the evidence shows, luminol testing was performed on the inside of Zach's van, and the entire van remained dark. See bottom portion of the picture. None of the phenolphthalein turned pink on the inside of Zach's van, meaning it was not BLOOD, because it is specifically used, this phenolphthalein is specifically used as a presumptive test to determine if it is human biological DNA. And it did not respond to the test, meaning it was negative. So all presumptive testing was negative, which means there was no BLOOD or bleach that had been used in that van. Julian Avila, one of the involved crime lab analysts, stated there was no indication of BLOOD in Zach's van. Okay, so why Dr. G's body language assessment about Zach is junk? So someone here, after Zach's sentencing hearing on May 16th, 2023, Dr. John Paul Garrison, or Dr. G, released a video on his YouTube channel analyzing Zach's body language at the hearing. Dr. G is a licensed clinical and forensic psychologist that creates, quote, clickbait videos analyzing body language in relation to high-profile crime cases. I'm just going to say right now, body language is junk science. There's no there's no scientific basis for body language. So dumb. Okay. Generally, if the person is found guilty of their charges, Dr. G focuses his analysis on confirming that guilt perception. So he'll go back in time or to be like, oh yeah, this is why this person is guilty. Look at their body language here. In the video about Zach, he reviewed snippets of the sentencing hearing and within seconds had labeled Zach a narcissist and a psychopath. He also noted that Zach showed no signs of remorse and he felt like Zach was flirting with the attorney, Nicole. I can assure you that's likely not true. Most people, they're friendly with their attorneys. You spend a lot of time, especially when you're incarcerated, they're like your lifeline to the outside. They are your team. Like, you need them for support. You grow close to your defense team over months of learning to get to know one another. All right, so as one might imagine, there were some glaring issues with this so-called body language analysis. Firstly, Dr. G was interpreting Zach based on the assumption that he was guilty of the charges, which is not how true body language analysis or psychological evaluations are performed. At no point did Dr. G make any disclaimers that psychological diagnoses cannot be provided without a full evaluation of the individual, nor did he acknowledge that body language in high-stress situations was not accurately or may not accurately reflect a person's baseline. Damn, that was a good sentence. Because you can't accurately predict anything about someone's behavior, I don't think, just by body language or what they're thinking, feeling. You can't predict any of that. All right, so additionally, he should have made note of the fact that there are external factors in such a situation that can alter a person's typical behaviors. In Zach's case, he was shackled, hands to feet. So he had his feet shackled together and his hands shackled together and on the thing, tied. So he had both tied together. and had a high-voltage taser pack strapped to his calf with metal prongs digging into his skin. That sounds awful. These factors make it more difficult for a person to act in accordance to their baseline. As a result of this video, a psychologist based out of UK provided a report rebutting Dr. G's video assessment and pointing out such inconsistencies. Her report is linked below. And I meant to open my document, so hold on one second. I didn't open my stuff before I started streaming. I forgot. I'm going to read through these documents. We have the analysis. Okay, so due to the fact that Dr. G is a licensed professional using the weight of his credentials to lend a perception of factual accuracy to his unprofessional and slanderous videos, a formal complaint was submitted to the Georgia Licensing Board of Professional Counselors. Dr. G has since removed his video. Excellent. Okay, so now we're going to read this is the letter that it was just referencing. So this is Lou Hillier, private consultant, chartered psychologist, lighthouse psychology, all these things. He's qualified. All right, so analysis of Dr. G's analysis video of Zachariah Anderson. Dr. G makes two fatal errors throughout, detailed below, which invalidate everything he tries to project onto Zach. So Dr. G completely failed to account for or even acknowledge that these two major factors that influence Zach's words and behavior at the sentencing hearing. So one, he failed to establish a baseline for Zach, and without a baseline, nothing Dr. G says has any validity. So bam. I mean, need you go further? Also, two, he failed to take into consideration the effects of the extreme context / conditions that Zach has been living under for the last 2 to 3 years. He had a mistrial, which made him stay in prison even longer before he got his day in court. So the first trial was a mistrial, thanks to some possible misconduct by the prosecution. So, and they tried to pull the same kind of tricks on the second trial. So, yeah. Anyways, I'll keep going. So he was under some stressful conditions. Dr. G failed to acknowledge or show any psychological understanding of the effects being incarcerated and isolated from loved ones, and how that will affect you. He failed to acknowledge or show any psychological understanding of the effects on a person of being in prison clothes, in chains, and in front of a judge who has complete power and facing a long-to-be-decided prison sentence. He failed to notice or acknowledge that Zach was choosing his words very carefully and that he was not free to say what he wanted to say due to restraints imposed by advice from his attorneys, and also knowing that if he said anything that, quote, upset the judge, he could end up with a more severe sentence. So he has every motivation, Zach has every motivation whatsoever to be on his best behavior at that moment and not say anything that might even slightly offend the judge, because he knows the judge carries all the power before him. And that is a very stressful thing. And that is a very stressful situation to be put under, especially if you are innocent. I'm sorry, if you are innocent of a crime that you're being charged of and you don't even know how. All right, so 2B. Did I finish that? Yeah. All right, so 2B. He failed to acknowledge or show any psychological understanding for the fact that Zach has had nearly 3 years to think about and rehearse what to say here. And therefore, neither Zach's speech nor his presentation of that speech will have been spontaneous but carefully thought out. Speeches that have been rehearsed and where the person is not free to express themselves openly and without censure cannot be analyzed in the usual way. Failing to acknowledge these contextual factors makes Dr. G's analysis doubly invalid. All right, so some specific accusations require additional comment. 1. Accuses Zach of only trying to appear happy because the smile is only on one side of his face? What? What a dumb thing to say. All right, so the camera shot was a side view of Zach as he was coming into court and gesturing to his family friends. So this observation is moot. He doesn't know what the other side of Zach's whole face was doing. That aside, Dr. G's implication that trying to appear happy is somehow a negative against Zach without giving a reason is highly questionable, and I would suggest fails to understand even the basics of human psychology. I would assume the opposite, that Zach is showing his sensitivity to his family and friends in concealing for their benefit how upset he might feel on the inside, and also I would interpret trying to appear happy as putting on a brave face, which is the behavior of a functional and emotionally competent human being as a way of trying to maintain some semblance of healthy self-esteem for himself and those who care about him in such extremely distressing circumstances. Mic drop. That's great. All right, number 2, accuses Zach of being a psychopath. This happens less than 90 seconds into the video. Dr. G calls Zach a type of psychopath that is manipulative, superficially charming, and charismatic. Firstly, these are not criteria on their own for being any type of psychopath. Secondly, that evidence was provided to justify giving the label of psychopath to Zach. Answer: none. Apart from Dr. G saying he knows that, quote, not everyone feels this way about him, but a lot of people seem to, end quote. So this supposed licensed therapist is asserting that Zach is a psychopath without ever having met him, nor establishing a baseline, nor speaking to any of his friends or family, and he has based it purely on what he thinks a lot of other people seem to feel. That's not scientific. Dr. G requires refresher training as he seems to have forgotten his most basic undergraduate training that feelings are unreliable sources of information and only wildly inaccurate. They're often wildly inaccurate and unreliable. Thirdly, every single human being alive is practiced in the art of influencing or manipulating other people and situations to some degree as we navigate the world and try to get our needs met. Wow, this person's awesome. Being able to influence or manipulate to some level is part of being a functional human being. It's for sure. As kids, we were always, pushing our parents' buttons and trying to get away with more. And, you do that your whole life. I like to push the boundaries, but not everybody does. But you should. You should push the boundaries. Anyways, Dr. G has provided no evidence to back up his claims that Zach shows a psychopathological degree of manipulation of others. The same can be said for the accusations of Zach being superficially charming and charismatic. These are characteristics that almost every human being has to some degree, and it is a sign of being socially competent when someone is able to be charming and has some charisma. Whether it is superficial or not is not a judgment that a stranger can make. No matter their profession or qualifications, people without charm or charisma will often struggle to form and maintain relationships both socially and in the workplace, and often find themselves isolated, alone, and with poor mental health. It is egregiously outside his scope of competence for Dr. G to attempt to label Zach as a psychopath, and grounds to report Mr. G to his licensing body. Damn. So not only should you not have called him a psychopath without any basis for that, but you should probably lose your license for that, or at least be sanctioned in some form, because you violated your own ethics. All right, number 3. characteristics of the type of psychopath Dr. G has diagnosed Zach as being. A. A. Nonchalance, being calm and composed, showing a lack of emotion. He may come across as disinterested/bored. None of these behaviors can in any way be taken as indicating a psychopathology or that someone is a psychopath. This is simply Dr. G projecting his own objects and subjective beliefs onto Zach. This is also an example of Dr. G ascribing to himself mind-reading capabilities that no human being has and is actually a sign of Dr. G's dysfunction and narcissism. Dr. G does not have sufficient knowledge of Zach to make any of these observations reliable, so all we get from his observations are a reflection of who Dr. G is, and they tell us nothing about Zach at all, in my view. I personally would make the observation that Zach being able to remain calm and composed under what must be immense emotional duress indicate he has good social and emotional intelligence and above average levels of self-control, especially that he is aware that his family and friends are watching and being mindful of their feelings, that they will not want to see Zach falling apart, even if that is how he might have felt on the inside. My observations would be that Zach showed significant empathy and appropriate emotional responsiveness towards others and what was happening in court during sentencing and throughout the trial. This observation is supported from reviewing multiple public comments made by his family and friends, and I would offer it is irrefutable evidence that Zach is not a psychopath. B. Manipulative, charm, and willing to breach boundaries. As discussed above, I interpret this as another invalid observation, as there is no evidence provided that Zach's reactions are anything other than within functional and normal limits of human behavior. Exactly, like he didn't do anything that would be manipulative or breaching any kind of boundaries when they did the sentencing hearing. He sat and he said, "Your Honor, I'm not guilty, I'm innocent," and he tried to defend himself in his own words, and the judge just, nobody cared. All right, additionally, Dr. G infantilizes the people that he is accusing Zach of nefariously manipulating and breaching boundaries with, predominantly his female lawyer. Dr. G is implying that she is too stupid to realize if someone is trying to manipulate her or intrude on her boundaries, and that she is too helpless and unfeebled to defend herself and to continue to behave professionally. Not only is this sexist and belittling towards Zach's attorney, Dr. G again shows no psychological understanding of human nature nor of psychological relationships, and instead seems to vastly underestimate and denigrate others whilst simultaneously evaluating himself as the all-knowing authority, which is classic narcissistic behavior. Oh my gosh, this is great. C. Narcissism. He probably believes he's the smartest guy in the room and that he will outwit everyone else, accusing Zach of calculating how he wants to appeal this case. Again, Dr. G provides no evidence for his observations. He cannot read Zach's mind nor anyone else's, so this is just more of Dr. G's self-objects that he is projecting out of himself and onto his target for denigration, in this case, Zach. I would therefore suggest that this is an embedded self-confession. Dr. G is telling us, without realizing it, that it is himself who is the narcissist and that it is Dr. G who thinks he is the smartest guy in the room. He does not have sufficient knowledge to make these assertions about Zach. They are coming from within Dr. G himself. They are all Dr. G's self-objects. His comments are nothing to do with Zach. They are Dr. G unconsciously describing himself and outing himself as a manipulative, calculating narcissist. That's funny. As for his specific accusation that Zach is calculating, how to appeal the case where Dr. G would use the word calculating to imply some perverse and devious intent. This just shows that Dr. G's ignorance of how trials and attorneys work and illustrates Dr. G's own twisted character in my mind. Or in my opinion, sorry. The reality is that Zach and his lawyers will have been exploring together reasons to appeal since the verdict, if not before, and this is entirely normal and functional behavior. Exactly. You're strategizing. All Dr. G is doing here is adding his biased and pejorative language in order to persuade the listener that Dr. G is good man, right? And Zach is bad man, wrong. This is purely showing us who Dr. G is. It is Dr. G who is being dysfunctionally manipulative at the expense of others for his own nefarious reasons, trying to paint someone else as a bad man, wrong, so he can bask in the glory of being the smartest guy in the room. D. Lack of genuine remorse. The glaring mistake made in this observation is that Zach cannot be remorseful for something he did not do. That Dr. G did not even mention the possibility that Zach may not show remorse because he has done nothing to feel remorseful about is a gross omission and is indicative of Dr. G's dysfunction and his biased, lazy, and distorted thought processes. Damn, this is great. Alright, so E, disrespect. Dr. G said because of Zach's facial expressions, he is being disrespectful, and this is a sign he's a psychopath. Really, being disrespectful towards others cannot in any way be taken as a sign or symptom of being a psychopath. If it were, then every human being on the planet is a psychopath, because all of us, from time to time, pull faces or roll our eyes or are flippant or rude to others, including this element is a sign of desperation and grasping at straws on the part of Dr. G. It proves he's got nothing of value to support any of the accusations, and he is, again, just projecting his own self-objects. This has nothing to do with Zach. It's just another example of an embedded confession from Dr. G. He is unconsciously telling us that it is he who does not have respect for others, not for Zach, not for his viewers, and likely no one else. F. Calculating. He is paying attention to people's reactions and thinking about his next move. Ooh. Functional human beings pay attention to others. We listen and modify our behavior in response to what we see and hear. This is entirely normal behavior. Again, Dr. G is using pejorative words like calculate to manipulate others and imply devious intent because Dr. G needs to persuade away from the reality that Zach is a normal guy. Dr. G is doing this either for his own nefarious and devious reasons, for views and likes, or to make himself feel better about who he is by denigrating another, and because he is just too lazy, ignorant, and or unskilled to be able to conduct a proper analysis. In reality, Zach behaved like a well-adjusted and sensitive human being, coping admirably with extraordinarily adverse circumstances. I mean, that alone is a great, each one of these arguments is great by themselves, but having all of them together, this is awesome. Like ripping apart what this guy is saying. All right, so in relation to Zach's attorney, Dr. G accuses Zach of doing these things, indicating an inappropriate relationship existed, and it was all Zach's fault. Looking at his attorney manipulatively, so he's saying he was looking at his attorney manipulatively. So what evidence does Dr. G give to support his assertion that a look can be manipulative? Answer, none. What explanation does Dr. G give for how to tell the difference between a manipulative look and a non-manipulative look? Answer, none. So yet again, all this is is Dr. G's projecting his prejudice and, in my opinion, his own dysfunction onto Zach, likely to make Dr. G feel better about himself and to make up for his own unacknowledged inadequacies. B. Looking at her chest, then looking her in the eye. This is another non sequitur agreement behind which there is no logic or evidence of devious intent, but Dr. G implies it nonetheless. Looking at an out-of-the-ordinary physical feature another person has is something that we all do. It's unavoidable and entirely functional and normal behavior when someone has a feature about them that is eye-catching in some way. Other people will notice it, and to notice they look, period. I would estimate there were approximately 0 people who did not notice Nicole's chest. Okay, alright, so C, trying to act nonchalant and cool. Again, no evidence provided to support this assertion, just an implication that his behavior was nefarious and negative to shore up Dr. G's baseless conclusion that Zach is a bad man. The bad man wrong. And Dr. G... Oh, what did I say? That Dr. G's baseless conclusion that Zach is the bad man wrong, and Dr. G trying to see himself as the good man. It shows me again that it is adept at Dr. G deluding himself that he has the ability to read minds, which no one else has, and further confirming to me that it is Dr. G who has the narcissistic tendencies. D. Being flirtatious and seductive. More projection and assertions made with no supporting evidence and failing to see the benign nature of the interactions between Zach and his attorney tells us that Dr. G's psychopathology and tells us nothing about Zach. Dr. G is either being insincere and playing directly to his dysfunctional audience of wino moms by deliberately misinterpreting innocent behavior in a way that reflects their own psychopathology in his own mind by telling them that what they want to hear about bad man wrong for clicks and views. Or Dr. G is demonstrating his own inner dysfunction and complete incompetence as a psychologist by attributing malignant intent to other people's benign behavior with no evidence or justification. True, other people's just acting normal, you know, and then people who don't like themselves will just rip on other people for no reason. It happens in my videos. I just delete the people. Like, whatever. You're not even commenting on the content. You're just ripping on me. So, goodbye. Like, we don't need that. You don't need to be rude to people. Lift people up. Stop bringing people down. It's so stupid. But anyways. In conclusion, there is nothing of value in the points that Dr. G tried to make. On the contrary, all that he showed was that he has a strong need to persuade, to manipulate, and control what other people think, projecting his own bad man wrong self-objects onto an unsuspecting character, in this case Zach, to make himself feel better about who he is. His entire analysis is a form of embedded confession that the very things Dr. G is accusing Zach of is simply Dr. G unconsciously describing himself. Everything he accuses Zach of are his own word or his own self-objects, and they come from within and they belong to him. As a final note, I wonder what secrets Dr. G may be hiding about his own character and conduct when he thinks no one is looking. I would suspect that sexual deviance may be a possibility due to Dr. G hyper-focus on the relationship between Zach and his attorney and repeated references to seduction and Dr. G's indirect sexualization of their relationship. Exactly. Men and women can just have a platonic relationship, and they can smile and laugh at one another's jokes and still just be platonic. And I don't know why everyone has to like put something on that, put something on them. That just shows more about the person making that judgment than the actual people involved. So this person, this Lou Hillier, concludes that it is Dr. G who has shown us the ugly interior of his dysfunctional, manipulative, and narcissistic character that he has projected onto Zach as a vain attempt to escape his own flaws and inadequacies. As I mentioned above, in my opinion, it is egregiously outside of his scope of Dr. G's incompetence for him to attempt this analysis, because he's never even met Zach. So nothing about his analysis could be trustworthy here. So to label Zach, in my opinion, grounds to report Dr. G to his licensing body. So for calling him a psychopath without ever having, witnessed or ever having met him in person or ever, analyzing or evaluating him in person, you can't say he's a psychopath, and therefore you should be not practicing anymore. All right, we got a little bit more to get through because this one's an interesting one. All right, so let's continue. I'll keep my water there. All right, let's continue on with this page down here. Oh, man, I didn't know it was in here. I downloaded it. That's okay. All right, so here now is why Nerita's testimony doesn't make sense. So this is actually Rosalio's building, which is 3709. You can clearly see it's lit up. It says 3709 right there at night. This is a picture taken at night. So main entrance to Rosalio's building at night. You can clearly see addresses of these buildings. So what to consider? The state's witness, Nerita Macias, originally provided a statement to Kenosha PD on May 20th, 2020, stating that she was supposed to be meeting up with Rosalio Gutierrez on May 17th, 2020, the alleged night of his disappearance. She stated that she had shown up at Rosalio's apartment at 9:34 p.m. and this was about 40 minutes late. So we don't know why she was showing up 40 minutes late without even calling him to let him know that she was going to be late. So she stated that she had shown up at his apartment at 9:43 and had sat in her car waiting for a response from him until 10:18. In Nerita's original statement, she stated the only people that she saw in that time frame were one heavy-set black female entering the apartment carrying a bag, and two, a young Hispanic male described as being in his early 20s, clean cut with no facial hair and wearing a white t-shirt. She witnessed the Hispanic male come down the stairs from the second floor, look out the front windows, and then go back upstairs. He did this twice. After waiting 44 minutes for a response from Rosalio, she left. Nearly 2 years after her original statement, Nerita was called into District Attorney D.A. Michael Gravely's office, and we'll talk about him in a whole nother episode. So she was called into DA's office to discuss her being a witness in this case. She was then asked by the DA to show them where she was in relation to Rosalio's building on the night of May 17th, 2020, and she met the DA and the assistant district attorney at the apartment complex, and somehow during this unrecorded exchange, there's no recordings, there's no notes about it, we don't know what was said, so her story changed, and they determined that she was in front of the wrong building. So she said she was in the right building originally in her first statement, and then by the time she meets with the DA and they take her to Rosalio's apartment building and discuss it, she changes her testimony, or she changes her statement and says that she was at the wrong building. So during her testimony about this exchange, she was adamant that she was at the wrong building in the first place. She states that it was dark and raining outside and that she never looked at the building number to confirm which building she was in front of. Why wouldn't you? Especially if you're meeting someone for the first time, you don't know where you're at. Wouldn't you look at the building number? She also provides testimony that she moved her car to 4 different parking spots while waiting, one of which is directly in front of the building. She maintained that she did see the 2 people described above. What the evidence shows, Rosalio's apartment 1B is inside of this 8-unit apartment building inside the entrance scene. Immediately to the right is a set of stairs leading up to the 2nd floor. Rosalio's apartment is the first unit on the right underneath the stairs. The apartment building number 3709 can be seen directly above the entrance to the apartment building with a light above it to illuminate it at night, as we just saw. So there is a panel of cross-hatched windows directly to the left of the main door, as seen above. Looking into these windows from the outside would provide a view of the stairs leading up to the 2nd floor. So, these windows, you can see the stairs leading up to the 2nd floor, so you could see people walking around in here. Where was I? So what does this mean? Although Nerita claims that she never looked at the apartment number on the night of May 17th, the evidence shows that it would be difficult to miss, especially if she was parked in a spot directly in front of the building, as she claims. Which, it wouldn't make sense for her not to look at the address when she's coming onto this apartment building for the very first time. Why wouldn't you look at the address? And your GPS would take you to the address, right? I mean, I don't know why. I don't know. All right, so the number sign is illuminated by the light above it. So even though it was dark and raining, the building number itself should have stood out in the darkness. Also, Nerita did maintain that her statement that she saw the 2 people described, which means not only did she have to be looking at the front of the building, but she did have to be close enough to obtain detailed descriptions of the people that were inside of the building, because it was dark at night. The likelihood that she would be able to describe that the young Hispanic gentleman had a clean-cut face, but see that the apartment number just above where he would have been standing at the window doesn't add up. Yeah. Nerita also had changed her testimony based on the private meeting with the DA, which raises a few concerns here. She testified that the DA gave her the address with which to meet him. This was at least 2 years after the incident occurred, and she claimed that she had never been to the apartments before or after the incident. So how do you know that the DA gave her the correct address and didn't mislead her to go to the wrong apartment for the sake of the case? There is no witness as of meeting. There is no witnesses of this meeting outside of Nerita, who works for the Milwaukee DA's office. What? And the Kenosha DA and ADA. She works for the Milwaukee DA's office? Oh, wow. Okay. That makes it even more fishy to me. Nerita and the DA both argued that Google Maps has an error where it directs to the wrong building even when the correct apartment building is input. Nerita claimed that she used Google Maps for the meeting, but evidence proved that she had actually used Apple Maps on the night in question. So again, how do we know that the result of where it directed her was the same, especially since she herself is unfamiliar with the area otherwise? Exactly, how would she even know? Even still, the DA requested that this meeting with Nerita, based on his knowledge that Rosalio had told Sadie in a text in February 2020 that Google Maps is often incorrect and leads to the wrong place. However, there is no evidence that Rosalio told Nerita about said error in May. So how do we know that this error was still occurring in May of 2020 and Nerita was the one navigating to his house? If it is still a known issue, wouldn't he have mentioned it to her like he mentioned it to Sadie her first time navigating there? It's a good question. Why didn't he tell her? So the changing of her statement is highly suspicious and possibly a sign of witness tampering on the part of the DA and perjury on the part of Narita. So for the sake of argument, it is possible that Narita just didn't know that she was in the wrong building on May 29th. However, the likelihood that someone navigating to someone else's house for the very first time and not ever looking at the illuminated building numbers to confirm their whereabouts, especially when they are sitting in their car staring at the damn building for 45 minutes, is implausible and unbelievable. I agree. That is unbelievable. When you're going to someone's house for the very first time, you double check, sometimes triple check, that that's the right address you're at before you go up to the door. If she had looked at the building numbers on May 17th, 2020, which is most likely based on the evidence and testimony as above, and confirmed that she was at the right building, then she changed her testimony to become more favorable to the DA's case and lied on the stand to aid Zach's conviction. The DA specifically focused on this witness because he knew the defense was using her testimony as proof that the timeline was even more impossible for Zach to have been involved. If Narita was in front of the correct building and did not see anyone or anything out of the ordinary before leaving at 8:10, that means that Zach would have had only 1 hour and 1 minute to somehow single-handedly get Rosalio's body into the van and get home to Mequon by 11:19. 1 hour and 24 minutes away by fastest non-highway, non-camera filled road. But that doesn't mean he wouldn't avoid all cameras if he went on the non-highway roads. All right. Back to the DNA in Zach's van. Why Lisa Treffinger's DNA testimony is misleading. On October 3rd, 2023, forensic DNA expert Tiffany Roy filed a formal complaint with the Wisconsin Department of Justice Division of Forensic Sciences in regard to the testimony provided by Lisa Treffinger, Wisconsin State Crime Lab analyst. During the trial, the state alleged that Rosalio Gutierrez Jr., his BLOOD, was found in the back of Zach's van. In fact, this information was released to the media by the prosecution's office years before the trial in order to make Zach seem like the guilty party to the local community and anyone reading the case, reading about this case in the news. However, in Treffinger's testimony, she states that the only BLOOD found in Zach's van was item A1, which was the size of a pinhead, a speck of reddish-brown substance. The crime lab collected the swab from the stain, and Treffinger stated the DNA matched Rosalio Gutierrez. However, she confirmed no testing was completed to identify the substance of that swab because it was too minuscule to run both DNA testing and presumptive blood testing. If it was that minuscule, would you even be able to run a DNA test? I know you don't need a whole lot of DNA, but I mean, if it's a minuscule amount, you might not be able to get the DNA, kind of like in Idaho 4 right now. However, the district attorney asked for Lisa Treffinger's opinion, and she stated her opinion is that the stain was blood that based on its appearance, and that the fact that it provided a robust DNA profile, which wouldn't be seen with skin cells. So that was her understanding as to why it was Rosalio's BLOOD and not skin cells and whatnot. Because remember, there are claims that Zach, when Rosalio traveled to Zach's house, it is believed that Rosalio went through Zach's truck, just like Zach supposedly went through Rosalio's truck, just to get even. And it's possible that Rosalio's DNA could be in the truck. So as you will see, but even so, and there's transfer DNA too, because of his daughter and, her leaving to, be with Sadie, Sadie could have transferred it onto her daughter could transfer it into the car. There's multiple ways that it could get transferred into his vehicle. But anyways, we don't need to get into that. Transfer DNA, and I don't think they're calling this transfer DNA, but all they know is that it's a pinhead-sized speck of reddish-brown substance, but they don't know what the substance is. They cannot identify it. As you will see in Tiffany Roy's complaint, Lisa Treffinger's statements of opinion and other assertion of fact is unfounded, baseless, and at times scientifically untrue. The claims that Rosalio's BLOOD was found in Zach's van are completely unsubstantiated and don't match the other evidence asserted in the case. All other presumptive tests on the van were negative, including several other reddish-brown substance stains, which, as I've said in other episodes, he had a saw that he used. They used tools that needed lubricating, and they had certain, like substances that needed to go onto their tools that would be, on a chainsaw or whatever. It would be red, like a red lubricating substance, almost like an oil or something. I don't know, but it is possible that it could be something other than BLOOD. All right, so here we're going to read that document, and then that would bring us to the end of this page. And again, here we are, 1,377 days, 10 hours, 51 minutes, and 54 seconds that Zach has been wrongfully incarcerated. We're going to come back to the website in a minute, but I just wanted to go over this. Okay, so this letter from Tiffany Roy, Forensic Aid. This is to Ava Lewis Marie King in Madison, Wisconsin. Ms. King, this formal complaint, I need this bigger. This formal complaint, you guys probably want it bigger too. Okay. This formal complaint is written to Nicole Rom, I'll say Rom, I have no idea, who is the administrator of the Division of Forensic Sciences, DFS, at the Wisconsin Department of Justice, the DOJ, about the testimony of Lisa Treffinger in the case of Wisconsin versus Zachariah Anderson. This testimony is publicly available on YouTube beginning at 5:14 mark of this video, so you can actually go back and view her testimony, and we can do that. I'll put her on the list of key witnesses. All right, so and the streaming of her testimony can and should be observed. It was provided to me by a lawyer / blogger who asked my opinion of the testimony for his research. Interesting. I love how YouTube now is totally involved in true crime cases and court proceedings. It's amazing. It's amazing. Some people think it's awful. I think it's great. We need more transparency, and we need all of this stuff to come to light, because there's so much that's hidden that we don't know, and we need to know. It's our country. We need to take it back. Anyway, so after reviewing her videotaped testimony, I had several serious quality concerns which I determined needed to be reviewed by the laboratory quality team. Normally, a complaint about quality concerns would be directed to the quality assurance manager at a specific crime laboratory. It is noted on the DOJ DFS website that there is a specific bureau in place to control and preserve efficient quality within the laboratory, known as the Quality Assurance Bureau, or QAB. I'm going to call them QAB. However, the search for a direct name, phone number, and email for the QAB was unsuccessful. The Bureau is meant to uphold their quality statement, which is... All right, okay, which is the Division of Forensic Services Quality Statement. To achieve and maintain accreditation under the International Standard General Requirements for the Competence of Testing and Calibration Laboratories, a forensic science accrediting body's supplemental requirements, and all other statutory regulatory standards required to provide forensic services and to use and support technically sound standards and guidelines of the Organization of Scientific Area Committees, registry as applicable. Quality support goals. The QAB works to uphold goals within the system of quality established by the DFS to provide high-quality, error-free forensic analysis which is able to withstand rigorous challenges, provide impartial reporting of scientifically accepted forensic analyses, maintain the integrity of submitted evidence by protecting it from loss, deterioration, and contamination, provide timely forensic services to the criminal justice system in the state of Wisconsin, ensure DFS employees are trained in the skills necessary to perform their work, ensure continual improvement on the quality system, and fulfill the DFS quality statement. So the last two quality support goals listed are meant to make quality control and assurance. So ensure continual improvement and fulfill the DFS quality statement. Though when I attempted to find contact information for this bureau, it was not publicly available, which defeats the goal of continual improvement of the quality system if complainants have no direct line of communication on laboratory product. The only contact information available for the DFS are phone numbers for each laboratory location, such as the Milwaukee laboratory, which number I called and was transferred between 3 different people over a 10-minute period of interrogation by laboratory staff. They asked me what my interest in the laboratory was, where I was located, what agency I worked for, and to what my complaint pertained to. None of those questions were appropriate, warranted, or germane to the inquiry. After 10 frustrating minutes, I was provided with the email address, kingEML@doj, whatever, dot blah blah blah. I'm not gonna read all that. I was provided the email with no name of the person who would receive the email or what their title was within the laboratory. I had to investigate this on my own after the call. In my research, I discovered Ms. King is the Forensic Sciences Director and not the Quality Assurance Manager. The difficulty I had obtaining the information to submit a complaint is unacceptable and something that should be investigated in and of itself as a quality matter. Damn. The complaint is about this complaint. So now we're finally getting to the complaint. That was all just complaining about not being able to complain. Now we are at the actual complaint, the reason why we're here. At the bottom of page 2. This complaint is about the testimony of Lisa Treffinger offered in the case of Wisconsin versus Zachariah Anderson. Upon review of her testimony, Lisa Treffinger reports that she took a position in the quality assurance program as a specialist. With such a position, she should certainly be interviewed about her sworn statements in the above-mentioned case and should not be involved in the investigation of this quality complaint. Ms. Treffinger made several misstatements and overstatements of the tests that she performed and the data she reported in the Anderson case. She makes statements when prompted that use the phrase reasonable degree of scientific certainty, which has no meaning in science and in the use of which has been recommended against. And we have a footnote here. That's from the National Institute for Standards and Technology, National Commission of Forensic Science. So I bet those people are pretty knowledgeable about what you should and shouldn't use. Alright, so she goes on to say that she can determine the source of the DNA generally by completing testing and providing evidence through, though this is one of the first limitations addressed by Peter Gill in the publication Misleading DNA Evidence Reasons for Miscarriages of Justice. And there's just the citation of that book. Or as an article. All right, so the source of crime scene DNA is unknown and unknowable. Source attribution for crime scene samples have been largely abandoned in forensic DNA for more conservative methods such as Bayes' theorem and the likelihood ratio. Source attribution is a victim of this uniqueness fallacy and misconstrues the meaning of the weight of the comparison. The random match probability nor the likelihood ratio have any correlation between the number of the people on the planet, and so when either number exceeds the number of people on the planet, that does not mean the DNA profile trait combination is unique to that person. Though we might expect a random match to an evidence DNA profile to be a rare event, rare events happen. Source attribution suggests the chance of random match is 0, and that is not the case. So, should I start? Okay, so trace DNA. Limitation, statement of limitations. So it is trace DNA. This is the starting position. Although a DNA profile has been obtained, it is possible neither to identify the type of cells from which the DNA originated, nor to state when the cells were deposited. It is not impossible to make any conclusion about transfer and persistence of DNA. In this case, it is not possible to estimate when the suspect last wore the watch, if it is his DNA, which this statement was originally used in relation to DNA evidence found on a watch found at the crime scene. This is from this case, Gill. Sorry. So if you're confused about a watch, it's about this case that they're referring to. Because the DNA test is very sensitive, it is not unexpected to find mixtures. If the potential origins of DNA profiles cannot be identified, it does not necessarily follow that they are relevant to this case, since transfer of cells can occur as a result of casual contact. Just like I said, Sadie could have skin cells or DNA from Rosalio on her. She can go home, hug her daughter, and then her daughter could go and later hug Zach that day, and he could have skin cells on him. She could be in the car after Rosalio was in Sadie's car. Sadie could have been driving with Rosalio in the car in the passenger seat, and then the daughter, OA, goes and sits in that seat, and she gets DNA on her from Rosalio, and then she transfers that to Zach. It's very simple, it's very easy to get transferred DNA, and that's why we need a much better understanding of DNA before we just go and say, oh, DNA matches, okay, guilty, because it's not that simple. And there's people that perform the tests, and there are ways to perform the tests. You have to follow the chain of custody so that nothing gets contaminated. You have to make sure that everything that you are doing is correct. I mean, there was aerial footage of the investigators of Idaho 4 dropping gloves on the ground, picking it up with their glove, not changing gloves, touching all of their tools with the same gloves that they picked this dirty glove up off the ground. So, I mean, that can contaminate. You can get a blood mixture from somebody else, or a DNA mixture, I mean. Something as simple as, scratching your nose, you, the investigator, with your gloves on, you're touching stuff, and then you're like, oh, my nose itches, and then you get it on your glove, and then it gets onto the evidence. It's so easy to contaminate. So we really need to know where our DNA is coming from, and that the chain of custody is not broken in any way. Anyways, so moving on. Sorry, I got on a little rant because I think DNA is not as conclusive as we all thought it was. Just like lie detectors aren't conclusive anymore, and bite marks aren't conclusive anymore. There are so many ways that junk science, we haven't caught up to it yet in the justice system. So we need to do our due diligence first before we just say, oh yeah, he's guilty. All right, so Lisa Treffinger fails to correct and in fact confirms that with the prosecuting attorney, her results can be stated within the standard of scientific certainty in the event of a question is asked, and her scientific opinions align with what is being implied or questioned. From the National Commission of Forensic Science within National Institute of Standards and Technology, a paper titled Testing Using the Term Reasonable Scientific Certainty was released. And, oh good, there's an article to it if you want it. Where did I just get that from? I always lose my spot. here. Okay, so the paper discussed the many issues involved when using the blanket term, such as its misleading guidance, non-scientific foundation, lack of specificity, and the term's criticism from academic and policy writing. This terminology is outdated and was not originally intended to be within the court system to verify scientific knowledge and expertise within criminal cases. The word reasonable degree of scientific certainty should not be part of any scientific explanation or presentation. Exactly. These are words suggested to scientists for lawyers as part of legal advocacy. Nothing is 100% in science, and therefore using phrases like scientific certainty are misleading to jurors and lay people who are unaware of the limitations and error rate of the science being questioned. Exactly. People are like, oh, that's an expert. He says his DNA matches. I believe him. Guilty. That's how easy it is to convict somebody. You get a good expert on your side, expert witness, who says scientific certainty, bam, you got yourself a guilty verdict. It's that simple. All right, so nothing is 100%. No human endeavor is without error and without limitations. Not correcting the attorney when she stated that the term of reasonable degree of certainty was a standard was error. Reasonable degree of scientific certainty has no meaning in science. No meaning in science. That is a legal term. Just repeating that for anyone that wasn't paying attention. Reasonable degree of scientific certainty is a legal term used to put people behind bars. It is not a scientific term. It may very well be a legal standard, but not a scientific standard, and Treffinger is not a lawyer at liberty to comment on legal standards. No, she is not. For all the pieces of hair evidence tested, she stated that they matched Rosalio Gutierrez without providing a statistic or likelihood ratio to give weight to the comparison. This makes the jury believe the hairs, toothbrush, and other items of evidence where source is attributed are undoubtedly belonging to a specific person because they are unaware of any statistics that state otherwise. Even if we believe that random matching of attributes would be rare, we never rule out that the DNA profile could be from a randomly selected unrelated person. The piece of evidence referred to as W1 was known to be the swabbing of a doorknob, and when questioned by the attorney about the source level attribution of the DNA from the swab, Lisa Treffinger said, "I believe this was a touch DNA swab." This testimony also exceeds the limits of the testing performed by Treffinger as stated by Gill more than 20 years ago. The cellular source of a DNA profile covered from an item is unknown and unknowable. On several occasions, Treffinger refers to the source of the DNA profile as skin cells, or in this case, or the case of the phone cell, her cell phone swab, Z1 touch swab of cell phone as skin cells. First, based on the testing that was performed in this case, they I was hearing a weird noise. Something, I don't know if you guys heard that. I heard like a tick, tick, tick noise. Maybe I'm hearing things. Sorry. Okay. So first, based on the testing that was performed in this case, they offer no information regarding whether the DNA from item Z1 is the result of touch or a sneeze or some other means of transfer. Second, the testing performed in this case cannot provide information regarding the cellular source of a DNA profile, even when serological results are considered. A telltale sign that this is not a scientific opinion based on sufficient facts or data is that it is not contained in the written report Treffinger produced. Opinions included in the report and notes from her testing would be technically reviewed, administratively reviewed, and subject to the quality requirements of accreditation and the Federal Bureau of Investigation. Wow, okay, opinions not included in the report are not subject to quality review. As such, They should not be offered as evidence. In this instance, Treffinger's opinion was pure speculation. Treffinger also answers in an affirmative about events that could have caused someone's DNA to be on an item. While it might be appropriate to educate the jury on research regarding transfer, persistence, prevalence, and recovery of DNA, those descriptions should not cause specific circumstances or evidence. I don't know. Should not be case specific circumstances. Oh, okay. So it shouldn't be case specific circumstances? I think I'm reading that right. I don't know. Let's read it again. While it may be appropriate to educate the jury on research regarding transfer, persistence, prevalence, and recovery of DNA, those descriptions should not be case-specific circumstances or evidence. Okay, now that made more sense. Treffinger confirms that she believes that the cells which are responsible for the DNA are skin cells or BLOOD cells, but does not provide the basis for her opinion. Yeah, where's that coming from? In fact, no serological data or results can inform a DNA analyst of these things. Her casework, training, and experience would not be sufficient to inform on such an opinion as the one offered here. She makes statements for several items that Rosalio Gutierrez is the source of the BLOOD on those items. She is connecting dots and making associations that are the province of the trier of fact. Screening tests indicate the prevalence of peroxidase activity, like peroxidase activity. I don't know if that's how you say that, but I've never seen that word. Peroxidase activity, not BLOOD. The hematrace test detects the presence of human hemoglobin, but also reacts with ferret BLOOD. Lisa Treffinger performed the comparison of DNA profiles from several items of evidence to the DNA profile of Rosalio Gutierrez, but opining on the source of the DNA profile as BLOOD and opining that the source of the substance was Rosalio Gutierrez was completely improper. I would ask the lab to review what actually is reported in her report to see how the statements made in testimony differ. So her testimony differs from her report. The reason these statements aren't included in the report is because it's an opinion that goes a step too far and exceeds the information modern testing can provide. This inclusion of source attribution statements in her report is problematic enough, but this coupled with the attribution of the blood to Rosalio is egregious. The reason that this opinion was not included in her report, not reviewed by her peers, and not consistent with the quality standards of the FBI is because these are not scientifically supported statements. She makes other statements that exceed her expertise, like using bleach to clean a car. Her responses to that line of questioning were purely speculative and based on no scientific evidence, tests, or data. The most serious misstatement during the DNA testimony were related to item A1. First, she states that what was observed for item A1 was so small, it was the size of a pinhead, so no serological testing of any kind was performed on that item. She speculates that given the color, I would say it would be BLOOD. This is completely inappropriate, knowing the extensive number of substances that can react with a screening test for BLOOD, which can also have the same color and appearance. Second, there are many kinds of BLOOD that don't come from human people that would react with a screening test if he was hunting at all, or if his brothers were hunting, or something, you know. I mean, there could be several other explanations as to what it is. It could be Zach's own blood from cutting himself on a tool or something. So there are many kinds of BLOOD and don't come from human people that will react this way. Sorry, my dog needed her blanket. Oh, she's being just a little butthead. Now she's getting back up and she's got to like turn and twist and find the perfect spot. Anyways, scientists can provide opinions using reliable methods and based on scientific facts or data to case evidence. Trevenger's opinion that A1 was BLOOD was based on no scientific tests, no scientific data. It was pure opinion and would never satisfy the legal standards that govern scientific evidence in U.S. courts. She appeared to use a process of elimination approach along with the physical appearance of A1 and proceeded to offer the opinion that the DNA on the item A1 came from Rosalio. In an email with Angelina Gabrielle, spelling unknown, I don't have the transcript. She previously recognizes in writing that she could not confirm A1 was BLOOD. The prosecutor asks her why her opinion here today differs from what she expressed in her email, and her justification was that Mrs. Gabrielle didn't ask my opinion. In science, an analyst's personal opinion does not matter. Under Wisconsin law, an expert can offer an opinion under 907.02. Which is, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, and experience, training, or education may testify thereto in the form of an opinion or otherwise if the testimony is based upon sufficient facts or data. The testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of this case. And 2, notwithstanding sub 1, the testimony of the expert witness may be admitted if the expert witness is entitled to receive any compensation contingent on the outcome of any claim. So they can't really testify if they have like a vested interest or preference. They're not supposed to be the trier of fact. They're just supposed to give you their observations, and the jury is supposed to be the trier of fact. So Trevenger testified that my opinion is that it was BLOOD when describing the possible cellular origins of item A1. This was based on no testing, no facts, no data. It was based only on the appearance of the stain. That is pure speculation. She further stated that skin cells don't give a robust profile, which is completely scientifically untrue, and that as to item A1, it is my opinion that it was BLOOD. I have never in my 16-year career witnessed a DNA analyst extend so far outside of their expertise. The renowned scientist Dr. Henry Lee was just personally sued in the state of Connecticut for offering an opinion that a particular stain was BLOOD without any proof that he performed any testing to support that opinion. Here, this witness freely admits it. This is certainly a violation of the ANAB guiding principles and any other ethical codes that this analyst may be bound to. The evidence presented at the trial of Zachariah Anderson was misstated and overstated in a very serious and unscientific manner, in a way that very likely convicted him, in my opinion. Immediate steps should be taken by this laboratory to review the testimony of Lisa Trevenger in this case and other cases. So not just this case, but who knows what other cases she might have done this to. So retraining should be required for this analyst and any other analyst from the state of Wisconsin laboratory system laboring under these misconceptions. Attorneys for both parties should be notified of the substance of this complaint, subsequent investigation, and remedial actions taken. So that was the letter from Tiffany Roy, basically ripping apart Lisa Treffinger's testimony. And I downloaded these, but they're all, those that we just read were on the Free Zachariah webpage as well. And I'm going to really quick, there's not too many. We're going to really quick go through these FAQs that are also on the website, because some people might need a refresher, and there was also really good information that are in these explanations here. So we'll go through these real quick, and then that'll be that. All right, so was there BLOOD in Zach's van? Frequently asked question. Per the testimony of crime lab analyst Julianne Avila, there was no indication of it in Zach's van. Both luminol and phenolphthalein were used as presumptive tests for BLOOD in the van, and both came back negative. You saw the picture, it came back black. I didn't see any luminol light up. So these compounds can also react to the presence of bleach, but neither showed any sort of reaction. So the state also said that he used bleach to clean up the back of his van, which also was very dirty, and it had carpets, or it had like bleach stains in the back. I don't know if it's on the carpet or what, but it looked like old stains. So anyways, but nothing showed a reaction to bleach or biological material. So the prosecution called a pinhead-sized speck of reddish-brown substance in the van BLOOD based on the opinion of crime lab analyst Lisa Treffinger. She had stated it was her opinion that that's what it was, but no confirmation testing had ever been completed to verify that opinion. She confirmed it was possible that the DNA found was from skin cells, aka DNA transfer, around an unrelated stain. So it could have been transferred. Was the DNA found in Zach's van confirmed to be Rosalio's? According to Lisa Treffinger, the speck of DNA came from a male single source profile, and when asked who it was a match for, she stated Rosalio Gutierrez. But there's no likelihood ratio that was given to confirm to what degree of certainty the DNA matched Rosalio. And I want to point out one thing. So, and I'm trying to think, there was an episode way back for Thought Riot podcast. They did they've done many episodes on DNA, but they did one that was really interesting where they kind of compared like what you learn as a specialist and an analyst, and like how to analyze the DNA. Basically, it comes back with like these markers, and you have to identify the markers. Well, about 99% of all of our markers, every living being on Earth has the same thing. It's just that like that 1% or whatever it is that's makes us unique and makes us different. So are they even looking at that 1%? You have to be sure like they've done the right kind of testing and they've extracted the right things to be looking at. And we don't have the full report. And like we read there in Tina Roy's letter, opinion shouldn't have been said in court. It's not necessarily, it shouldn't have been her opinion of what it was. It should have been based on scientific data. So when was the DNA in Zach's van discovered? Initial testing and evidence collection inside the van was performed on May 21st, so 2 days after after he was reported missing. According to Kenosha Police Department, they did not receive a result on the DNA in the van until December 11th. That's a long time to wait for DNA. I don't know. They also went back to the van, so that's interesting. Did Zach buy sardines to cover the smell of his van? Zach purchased cans of sardines at Walmart on the 18th during his shopping trip for other household items, including bleach wipes, so like Lysol wipes or Clorox wipes, whatever they were. At the time, if you could find them, you picked them up because it was the height of COVID and everybody was grabbing latex gloves and face masks and bleach and things to clean and hand sanitizer. So he also bought Q-tips, gloves, a razor, Old Spice, garbage bags. Now, does this seem like a shopping trip that someone with a body in their van would be doing? No. And he was leisurely walking around for like 20-30 minutes. He enjoys eating sardines and would often purchase them for on-the-go snacks. His defense attorney, Nicole, noted that although the cans had clear lids, they were found unopened. Why was the carpet removed from the back of the van? Zach often used his van as a work vehicle, including hauling refuse from demolition projects that he did on the side. He also hauled tools around, either for personal or work use. Per Zach, some gasoline had spilled in the rear of the van. Rather than inhaling the fumes or bothering to try to clean a beat-up old van, he cut the affected piece of carpet out, which was like tiny comparative to a 6 foot, 270-pound man. He cut like a piece of carpet out like this big. It wouldn't no, I don't know. When was the carpet cut out of his van? According to Zach's daughter, she saw the carpet intact on May 16th. She stated she was sitting in the front of the van and the rear seats of the van were in at the time, and with junk strewn around the floor in the midsection of the van. So how would she see? She wouldn't be able to see the back of the van because it was taken out of the back of the van. According to Zach's employer, Susan Brown Williamson, she had witnessed the carpet removed prior to the weekend of May 16, 17. She stated that the last time she saw him, she was standing on the driveway at the house he was working on, and then she saw the doors of the van open with a bunch of stuff piled in. She notes there was no carpet in there, and she watched Zach close up the van and hook up her trailer to haul construction debris away. When asked why she had never mentioned this to law enforcement, she stated she did tell them it was gutted, but may not have specifically mentioned the seats or the carpet being removed. So she doesn't remember she told them that. The burn pit. Why did Zach have a burn pit in his backyard? Zach's home is situated on almost 5 acres of land in rural area. In rural areas in the state of Wisconsin, homeowners can apply for a yearly burn permit to dispose of certain household trash and yard waste. I did not know that. According to the Wisconsin Department of Natural Resources, state regulations allow individual households to burn small amounts of dry household rubbish, which includes only unrecyclable paper and cardboards, natural fibers, clean, untreated wood, and similar materials, and yard waste. Per the testimony of Kurt Zellner, Deputy Fire Chief, Zach had a current burning permit for the year 2020 that was valid through the end of the year. There you go. Were Rosalio's clothes found in the burn pit? Although certain news articles stated that pieces of Rosalio's clothing were found in Zach's burn pit, this information is categorically false. No testimony in the trial or police investigative reports ever documented that any clothing or DNA belonging to Rosalio Gutierrez was found in either the burn pit on Zach's property or on the Anderson tree farm. All clothing items found in the burn pit belonged to Zach and had only his DNA on it. All right, so why would Zach burn his clothes unless he was concealing a crime? Per the testimony at trial, police found 2 Levi's jeans buttons, a partially burned sock, the elastic from a pair of underwear, and the steel toes from a pair of boots. Mind you, Zach did construction and stuff, so it's very possible he had his own steel toe boots. Although these are not the only articles of clothing found in the burn pit, these are the only ones that were presented at the trial to make it seem like he had only burned one set of clothing in an effort to conceal some sort of evidence. So there's more clothing in there, but because they mention a sock, underwear, pants, a shirt, steel toe boots, that's one outfit. That's like one person's clothing. But Rosalio wasn't wearing jeans. He was wearing sweatpants, remember? Everyone said he was in sweats that day. He was in gym shoes. So there's that. Because it's what the mothers of his children said that he was wearing that day when he dropped the kids off. Alright, so although these are not the only articles of clothing found in the burn pit, these are the only ones that they presented to make it seem like he was hiding the crime. As more information is released, it will be clear that Zach regularly burned clothing. The burning of these clothes was not an isolated occurrence, rather than pay the cost of disposing old clothing items in the dumpster on the property, which is rented and paid for by weight, and was otherwise used for Solomon's construction business. He chose to burn them. Why did Zach shush his daughter while she was testifying? And it really did look bad, and the media made it look really bad. He went because his daughter was trying to talk to him on the stand. So here's what they say. To clarify, Zach and his daughter had not seen one another for 3 years. Emotion could be seen on Zach's face throughout her testimony. What you could not see was the minor daughter had similar emotions and attempted to mouth things to him between questioning. So she was trying to talk to him between all the questions. And she was not sitting still and, paying attention to the lawyer that was interrogating or asking her questions. So Zach attempted to have his attorneys intervene, but when that failed, he made a motion for her to stop mouthing words to him. Similarly, the daughter's mother, Sadie, mentioned to her to calm down using ASL, American Sign Language. Both parents of the minor child made attempts to shush her. Unfortunately, Zach's was highly publicized and turned into something to use against him because it was caught on camera. They didn't show Sadie shushing her, but you could see, but she admitted to shushing her using ASL. Sadie taught OA at a young age to sign, so that's a big deal that she also did that, but whatever. Alright, so why did Zach's daughter testify against him? The full truth is unknown. However, most likely OA was subpoenaed to testify by the DA and had no choice in the matter, or her mom made her to. So she was used as a material witness because Sadie told officers at the scene of the crime that OA had information pertinent to Zach's stalking behaviors and the disappearance of Rosalio. Sadie told officers that, so that is why he became a suspect. By making such statement and agreeing to bring her daughter in for questioning, like I said, you can watch the video of Sadie, and at the very end, OA comes in and they're talking, and you can hear their interaction. So it's possible OA was forced by Sadie to be a part of this trial and to speak against Zach. Did Zach threaten his daughter with a weapon? No. During her testimony, OA states, "I was threatened with a GUN for your information." She just blurted it out, like I said, and it was not, I believe it was they struck it from the record, but, or at least she told the jury to disregard it. So she said she was threatened for your information in reference to an unregistered weapon that she states Zach owned. Initially, she stated that an unregistered GUN existed in California. However, when questioned further, she inferred that the GUN was in Wisconsin, but was unable to provide further details other than it being black, maybe some sort of pistol, and it was at Zach's house at some point. Nowhere in her testimony did she ever state that Zach threatened her with it, and that the jury was directed to disregard the statement as irrelevant. OA herself even stated that the GUN was not related to this situation. It wasn't until the judge addressed her directly and told her to listen to questions carefully that she made the utterance, because she wasn't answering correctly, and she was trying to talk to Zach the whole time because they hadn't seen each other in 3 years, which is just insane. So in fact, any mention of the gun by OA is extremely puzzling, as Zach has never owned one in Wisconsin. Even Sadie, who has been in an on-again, off-again relationship with Zach for roughly 12 years by this time that he was arrested, had no idea what OA was referring to. Zach is very anti-GUNs, and particularly because he was robbed by one when he was 19 years old. Additionally, there is no evidence of him ever owning any firearms or ammo or anything, and they looked for firearms, ammo in the search, and none was located. All right, the timeline. How much time was there between the proposed time of death and Zach's cell phone use at home? So according to the state, Rosalio is believed to have been, for his life to have been ended sometime between 9:30 and 10. The last known activity on his phone was an orientation change that occurred at 10 p.m., or 10:10 p.m., which means someone had to be handling the phone inside his apartment at that time. Zach was pinged at his home in Mequon at 11:19 p.m. He made a phone call there. Or no, he sent a text there. I thought it was a call. And he did both. Sent a text and a call to his girlfriend. His drive time from Rosalio's apartment to his home would have been an hour and 1 minute at the very best, if he didn't run into any traffic, any problems. And, making all the lights probably, leaving only 8 minutes extra to dispose of a body in a way that still has not been found to this day, 3.5 years later. The timeline is simply impossible. Please see the unseen evidence page, which we already read through today. Investigation. Was Sadie Beecham ever investigated? No. Sadie did willingly allow a download of her cell phone contents and provided statements to the police, but she was not investigated as a potential suspect for the crime. This means that they did not search her vehicle, her home, her computers, her social media, or anything else that could potentially be relevant to finding the whereabouts of Rosalio. Her alibi for the time in question is unknown. And remember, her and her friend Rebecca were texting things like it'll happen in a week, and Rebecca said she'd take care of it. It would happen in a week, but we don't know what they were talking about because there were text messages that were deleted on Sadie's phone. All right, so was Michael Campbell ever investigated? No. Around the time of Rosalio's disappearance, Michael Campbell was only asked to provide a statement to the police in 2022. Zach's defense attorneys requested that the district attorney obtain phone records from Mr. Campbell. According to DA Michael Gravely, they essentially apologized for the inconvenience to Mr. Campbell and asked if he would be willing to provide his phone, which he did. Kenosha PD did not search his vehicles, his trailers, his home, his computers, his social media, or anything else that could potentially be relevant to find the whereabouts of Rosalio. His alibi for the time in question is unknown. Did Kenosha police investigate anyone other than Zach? The answer to that is also no. When asked who else the police investigated other than Zach, Detective Anschutz testified, "Personally, I didn't investigate into anybody else. We looked for other leads, other clues, other evidence, but personally, I didn't take the initiative to go look specifically at somebody else." I mean, what? You're putting someone behind bars for the rest of their life, and you don't look at all avenues? Why didn't Zach testify to prove his innocence? And let's let them answer it. A defendant's right to remain silent is protected by the Fifth Amendment of the United States Constitution. It is not the duty of the defendant to prove anything, including his innocence. It is the duty of the state to prove that the person on trial is the one that committed the crimes as charged beyond a reasonable doubt. As in most criminal proceedings, it was the defense's advice for Zach not to take the stand to testify. Most criminals do not take the stand in their own defense because it opens you up to questioning from the other side, and things can come out that you might not want out. Like, not centered in the screen. Oh, darn it, dog. I'm not getting up. Anyways, so where was I? Testifying can be stressful, intimidating, and overwhelming. Some people do not perform well under pressure and might become agitated or nervous. A jury may wrongfully interpret his behavior as a sign of the defendant's guilt. It's another reason why you don't want to take the stand in your own defense, because if you're nervous, you could be, the jury could read that wrong. Per Sadie's testimony, Zach had texted her stating that he had lost his phone and asked if she had seen it. He mentioned how he had already looked for it in several places and thought maybe he dropped it in the car when they were exchanging the kids. Sit. Lay down. I don't know if you saw her trying to get into my face, but she was trying to get in my face. All right. Okay. 1 minute. I gotta let them out, probably. All right, so Sadie quickly assumed that Zach had placed the phone in the vehicle on purpose with the intent to track her movements. I think Sadie stole the phone to make it look like Zach was tracking her, so she had evidence for the cops. Potentially, maybe, allegedly. I don't know. It's a possibility. So per their text conversation, she stated that he admitted to stalking her, which now we know that she made him admit that in order to get the phone back. To which he responded that she forced him to say that before she would give him his phone back. Why did Zach involve his daughter in stalking Sadie? Zach admitted to police during his interrogation that he had brought the kids over to Sadie's home the night of April 24th, 2020. OA was 11 at the time, and she was upset about her parents' split. Up until that point, she had always known her parents to be together. OA was mad at Zach that day because she felt like his relationship with Christine was the reason he and Sadie weren't together any longer. Zach attempted to explain to her that Sadie had also been spending time with a new love interest, but OA did not believe Zach, and Sadie was in total denial. She wouldn't admit it to Zach. So rather than continue to argue with his daughter about it, he told her that he would show her with her own eyes and brought her over to Sadie's so that she could see for herself that Sadie had moved on too. And that is the end of this episode. That's the end of the unseen evidence. We are going to do a little bit about the mistrial in the next episode. And then after that, we'll talk about District Attorney Gravely and trying to remove him from the case. So I still have, and then we're going to do the Denny motion too. And I might do that one live. Not sure. But I think I might do that one live. So we're going to read through a lot more. There's still so much more to go. So please be sure to subscribe so you don't miss the updates on this case and cases like it. I love to find cases like this where someone's innocent and we can prove that they have been wrongfully convicted or, wrongfully charged with things that there was no basis for. So on that note, thank you so much for watching. I hope you enjoy your day and take care. Don't forget to like, comment, subscribe. I'm out of here. Bye.